Hello, let me introduce myself. My name is Kennix. I am a college student from International University of Batam, currently on my third semester in the Faculty of Law. The topic that I will be bringing in this video presentation is about private international law in Indonesia. Before we talk about the main topic, let me tell you first, what is private law? So, private law is a provision that regulates the rights and interests of individuals in society. In the legal traditions in continental Europe, there is divisions of law into two, namely public law and private law, whereas the Anglo-Saxon system, there is no divisions of it. Indonesia is a country that adheres to the continental European system. So we have Indonesia's public law and private law. Private international law refers to the part of the law that is administered between private citizens of different countries, or it is concerned with the definitions, regulations, and enforcement of rights in situations where both the person in whom the right inheres and the person upon whom the obligations rest are private citizens of different nations. It is a set of rules and regulations that are established or agreed upon the citizens of different nations who privately enter into transactions that will govern in the event of dispute. In this respect, private international law differs from the public international law, which is the set of rules entered by the governments of various countries that determine the rights and regulate the intercourse of independent nations. International private law begins work when a court of law is confronted with a lawsuit that has a foreign element. Foreign element. What is foreign element? Foreign element means simply a contact with some system of law other than our country law or Indonesia law. Such a contact may exist, for example, because a contract was made or to be performed in a foreign country, or because a tort was committed there, or because the property was situated there, or because the parties are not Indonesian. The foreign element includes citizenship, flag of ships, domicile, place of residence, nationality, choice of international law. Link point. In international private law, there is a link point or connection point that is a state of knowing the facts that cause the enactment of legal system. There are two kinds of link points, namely, first, primary, and second, secondary. Primary. Its distinguished points of connections are factors or conditions of factors that give birth or to create relationships in international private law. Primary link points are the foreign element in international private law, which are citizenships, flag of ships, domicile, place of residence, nationality, and choice of international law. Secondary. Linkage are factors or groups of facts that determine which law should be used. Secondary link points embrace the following points: the place where objects are, or lex cite, the place where the legal deeds are implemented, where the unlawful act or lex loci delicti omnissi, the place of marriage or lex loci celebrationis, where the contract is signed or lex loci contractus, place of contract or lex loci solutionis, choice of law, nationality, flag of ships, domicile, place of residence, status of legal entity, and movable objects following the person, or domicile or nationality of the different. There are few steps of case settlement using the link point methods. Determine the primary link point because it tells whether it is a private international problem or not. In this stage, we will look for the elements in the set of facts encountered. Qualifying the facts based on the lex fori to determine the juridical category of the case. To decide which private international law rules from lex fori should be used to determine the lex causae. At this stage, people actually determine from the most decisive secondary link points. If the rules of internal law can be determined, then the case can be decided. Now I will tell you the development of private international law briefly. So, during the Roman Empire, it had created the laws of the Roman chiefs, ius civili, which then developed into ius gentium. What is ius gentium? The ius gentium or jus gentium, Latin for law of nations, is a concept of international law within the ancient Roman legal system and Western law traditions based on it. The ius gentium is not a body of stated law or a legal code, but rather customary law took to be held in common by the genders or the peoples, in recent compliance with standard of international conduct. Ius gentium consists of ius privadum or private law and ius publicum of public law. Main containers of private international law. In Indonesia, private international law's major containers are mentioned in AB, Algemeen Belpalingen van Wetgeving Article 16, 17, and 18. These three articles are basic provisions about private international law because that is why they are included. AB is a temporary law because there are guidelines for judges in carrying out their duties that not only cover the field of civil law but include the other areas of the law. The contents of the three articles AB above are: first, Article 16 AB personal status and authority. A person's status and authority must be assessed according to his national law or lex patriae. So, a person wherever he is still bound by his law regarding status and authority as well as foreigners, meaning that the status and authority of a foreigner must be assessed with the foreign national's law. Second, Article 70 AB status real and real status. Regarding objects, it must be assessed according to the law of the country or the place where the object is located, or lex recital. Third, Article 18 AB mixed status. The mixed status of the form of legal action is assessed according to the law where the action was carried out or locus regit actum. Source of private international law. International law, also known as law of nations, is the name of a body of rules which regulate the conduct of sovereign states in their relations with one another. Sources of international law include constitutions, tractates, jurisprudence, and customs. Constitutions and tractates are classified as written law, while jurisprudence and custom law are classified as unwritten law. Provisions. Provisions of private international law is classified into two. First, the reference rule. The three articles mentioned above, which are Articles 16, 17, and 18 AB, are examples of referral provisions referred to as referring provisions because they refer to a certain system of national law or foreign law, applies in the country of the foreigner who orders in the case being faced apply foreign law. With the foregoing, that is where the judge's law designates the law of foreigners. Therefore, the case is tried based on the foreign law. That is why the private international law is appointed or referenced. Second, independent rule. There are times when it is felt to be in accordance with our legal ideals if a certain material matter is controlled by a foreign law or that foreign law is felt to be insecure, guaranteeing legal certainty in this case. The makers make their own regulations that directly resolve the problem without referring to a particular legal system provisions. Provisions such as this is called the independent rule. Theory about qualifications. In every legal decision-making process, qualifications action is a practical action and the reason is always done with qualifications. People try to organize a set of facts that are faced by detecting and placing it into a certain category or group. Why is qualification important? In private international law, this qualifications issues is important because in private international law cases, people tend to always face the possibility to applying more than one legal system to regulate a certain set of. In private international law, there are two types of qualifications, namely, classifications of law. Classifications of all rules of law into certain legal groups that have been previously established by law. Second, classifications of facts. Qualifications carry out on a set of facts in a legal event to be determined to be one or more legal events based on the legal categories and legal norms of the legal system that are considered supposed to apply. In this segment, I will talk about how is the qualifications theory based on the lex theory. Qualification theory based on the lex theory is spearheaded by the Franz Kahn from Germany and Barthin from France. Qualifications must be carried out based on the law of the court that hears the case, or lex theory, because the qualification is part of the judge's internal law. The reason why Franz Kahn did qualification based on the lex theory was simplicity. If the case is qualified based on the lex theory, of course the judge who understands the trial really understand about the law and which law will be applied to the case being faced. Then, certainty. People who have an interest in the case in generally know as a legal event what the case is and will later be credited by the judge into the legal events they already know and all these consequences. How about Barthin's reasons? According to Barthin, if a judge applies a foreign law to the case he is facing, he does it on the grounds to limit the sovereignty of lex theory. The limitations of lex theory sovereignty is carried out that the provisions of foreign law are the meaning or degree or in terms of justice compared to the balanced lex theory law. If the judge does not find his own law in the concept of foreign law, he must find his own legal concept which is equivalent to the concept of legality sincerely, or establishing himself as the lawmaker or constitution. In the existing provisions, it is not necessary to apply the law of lex theory or the judge's law. In some cases, There are exceptions as stated in Article 17AB. With respect to fixed objects or movable objects, the applicable law is the law of the place where the object is located. Article 18 of AB. The law that applies to contract is the law where the contract is called the lex loci contractus. Qualification theory based on the lex fori certainly has its own advantages and disadvantages or weakness. The following are the advantages of qualifications theory based on the lex fori. First, the matters can be quickly resolved. Second, decisions given by judges will approach justice. Third, the judge is fully aware of the law regarding the case he is facing because the case was clarified into the lex fori. Sometimes the qualifications in the lex fori legal system are incompatible with the size, category, or even the sense of justice is unknown to the foreign system. If we compare both of it, the advantages of this theory based on the lex fori are still more than the weakness. So, in my opinion, this theory is still a good choice of theory to be applied. Done with the material study, now we are going to jump into the case study. In this discussion, I will talk about 3 real cases and 2 hypothetical cases. So, let's get started. The first case is about an egg against the law case between a lawyer from the US and a vet of a Bogor Agricultural University or IPB from Indonesia. Let me tell you the chronology before we discuss this case any further. Bogor Agricultural University or IPB entered into an agreement to send 800 monkeys to America. The monkeys will only be taken their children, and the baboons will be returned to Indonesia. Price per monkey is agreed upon 80 million and the US needs their children and it must give birth to the children in the US. When the aircraft was still in Switzerland, a monkey was stressed and loosed. It gave birth to its child there. Because the mother had been paralyzed and died, the vet of IPB injected the monkey to death because of pity. Lawyer of the US is demanding IPB on the basis of animal protections and is deemed not to fulfill his achievements perfectly and to kill a monkey child. On the other hand, monkeys in Indonesia are no more than pests, while in the US, it is an animal that must be protected. The parties of this case are US represented by the lawyer and IPB represented by the vet. Of course, from the former sentence, you already know that the nationality of the both parties are United States for the lawyer and Indonesia for the vet from IPB, which in private international law, it is the primary link point. How about the secondary link point? From the agreement between IPB and the US, there is no legal choice or forum choice that is explicitly regulated. Then, the secondary link point is more than one, which are lex loci contractus, the law where the agreement was held in Indonesia. Then, lex loci delicti commissii, the law where the act is against the law carried out in Switzerland. And lex loci solutionis, the law where the agreement is carried out in United States. And the most characteristic connections or the more prominent party in the contract is Indonesia or IPB. There are several choices of law in this case to determine where this case will be resolved. First, Indonesia. Based on the party's nationality, which is fed from the IPB based on where the agreement was held, and also based on the domicile of the defendant, which is IPB, whom resident in Indonesia. Second, US or America. Of course, based on the party's nationality too, and based on where the agreement is going to be carried out or lex loci solution is. Third, Swiss. In this case, there are an act against the law committed in Swiss before arriving in US to carry out their agreement. So it is based on where the act is against the law is carried out or lex loci delicti commissi. The law and forums used in this case is Indonesia's. Why? Simply because of the primary and the secondary link point that we connected. Indonesia is the most relevant to the case. For example, the residence and nationality of the defendant, where the agreement was made and the object of the agreement. Hence, this case is resolved in Indonesia. Why is this case is classified as private international law case? Because it got its foreign element in the whole case. The foreign element means element that is not from or occur in Indonesia, such as the lawyer representing the US or parties, the contract that is going to be carried out in the US based on the agreement, and the act against the law occurred in the Swiss. All of that is considered as the foreign element that made this case as an international private law case. The second case. The second case is about an American couple fighting for their daughter's custody right using the law in Indonesia. Let me tell you the chronology of the second case. On 23rd of May 1997, Purnima Rarahan or the applicant married Jonathan Keane or the respondent in Philadelphia, United States. Then they decided to move to Indonesia in 2000. They was blessed with a daughter named Lara Rose that was born in Indonesia, Jakarta on 24th of December 2001. During the stay in Indonesia, the wife lived with the husband and their daughter in the Kuningan area of South Jakarta. In the beginning, their family proceeded harmoniously, although there were often conflicts and quarrels, which were later followed by acts of violence. Until 19th of August 2007, there was a fight in which the husband threw the glass until it broke in front of their daughter, so that it had a psychological effect on the development of her soul. On 20 August 2007, the wife and their child left the place of residence and settled temporarily at the home of the wife's parents, who were in Kuningan, South Jakarta. After returning to their house, on 30 August 2007, violence again occurred where the wife was dragged and thrown from one to the other end of the bedroom. The act was again carried out in front of the child. After this accident, the petitioner or the wife returned to live temporarily again at her parents' house in the Kuningan, South Jakarta. Then on 22nd September 2007, the husband hit a round table in the living room of the wife's parents' house in front of his wife, in-laws, and daughter. The husband took away his daughter by force, which was later prevented by the wife, but the wife was pushed to hit the table and fall. Both parties in this case were United States citizens, which means the nationality is American, and they also carried out their marriage in Philadelphia, US, Lex Loci celebrationists. They then moved to Indonesia and domiciled in Indonesia for quite a long time. Their daughter Rose is born and raised in Indonesia, Lex domicile, but her nationality is still American following her parents. While living in Indonesia, the husband commits domestic violence and causes the wife to sue him for a divorce. Lex Loci Delicti Commissi. There are two choices of law in this case to determine where the case should be resolved. Indonesia, based on the both parties' domicile and Lex Loci Delicti Commissi where an act against the law, which is the domestic violence, happened. America, based on the both parties' nationality and Lex Loci celebrationist. Initially, this case could not be tried in the Jakarta District Court because the validity of the marriage of the two parties could not be recognized in Indonesia. But due to attention to justice for the parties, which is the case, could not be sued in Philadelphia because of the bona fide resident principle. The panel of judges decided to grant the petition filed by the petitioner, but the court decisions only cover the temporary transfer of parental rights named Lara Rose from the father respondent to the mother petitioner, instructs the Indonesian National Police and other authorized agencies to provide protections for the petitioner, her daughter, and the petitioner's parents, and granting authority to the petitioner as the child custody holder to transfer the KITAA's residence permit on behalf of Lara Rose from his father to the petitioner. So, here applies the theory of renvoi, which means the court and the law used in the court and the law where the lawsuit filed was filed. The foreign element. It is very clear here that the foreign element are the both parties who were an American citizens and the Lex Loci celebrationist, which also occurs in the US. Thus, this case is certainly a private international law case. The third case. In the third case, I will tell you briefly about a dispute between Jenny Versasi SPA and an Indonesian citizen named Sutarjo Jono, who is suspected of doing plagiarism of the Versasi's trademark. The chronology. The company Jenny Versasi SPA was founded in 1978 by a prominent designer named Jenny Versasi. Jenny Versasi SPA is one of the world's leading fashion companies. This company designs, manufactures, and distributes its products in the form of clothing, jewelry, cosmetic, perfume, and other similar products. Then, the defendant was Sutarjo Jono, an Indonesian citizen domiciled in Medan, who was allegedly involved in fraudulent competitions in the business sector by plagiarizing Jenny Versasi SPA and registering a trademark that was almost the same as the name Versus Versasi. The Jenny Versasi SPA is the rightful owner of the Versus Versasi, Versasi Classes V2, and Versus Versasi trademarks, which have been used, promoted, and registered in their home country of Italy since 1989 and also registered in 30 more countries. So that the Versasi's trademark, based on the Article 6, Paragraph 1, Item B of Law Number 15 of 2001 concerning trademarks, is qualified as a famous trademark, where the disputed trademark is the plaintiff registered trademark. The parties of this case are Versasi SPA from Italy, that domiciled there and an Indonesian Sutarjojono domiciled in Indonesia. Jenny Versesi SPA possesses Versus, Versesi, and Versesi classes V2 and dominates the fashion markets of various countries in the world. Sutarjojono alias Jono registered its brand called V2 Versi Versus in Indonesia, which caused the controversy with Jenny Versesi SPA, thus we can specify that Lex Loci Delicti Commissi of this case was happened in Indonesia. There are two choices of law in this case. The linking point, Indonesia, based on Lex Domicili and the Lex Loci Delicti Commissi. Jono, whom resident in Indonesia, registered V2 Versi Versus with the Directorate General of Intellectual Property Rights Indonesia. Italy, based on the domicile of Gianni Versesi SPA. The Central Jakarta Commercial Court Judge Panel in the case of Gianni Versesi SPA against Sutarjojono took the interpretation of fraudulent competition based on the provisions of elucidations of Article 4, Act No. 15 of 2001 concerning trademarks of the Commercial Court Judge's statement regarding fraudulent competitions. Considering whereas from the elucidations of Article 4 based on the interpretation of a contrario, there are two important elements to determine the existence of bad faith, namely, there is an intention to benefit the registrant's business while at the disadvantage of other parties. Second, through consumer misdirections or fraudulent competitions, or copying or riding on other people's brands' fame. So this case can be solved by using Lex Causae and Lex Fori from Indonesia because of the residency of the defendant is in Indonesia. Here comes the first hypothetical case. It is about three friends going for a trip to Australia and an accident occurred there. In the hypothetical segment, I will tell you the characterizations alongside with the case chronology. So Jojo, JJ, and Juju were a group of friends who loved to travel together. The three of them were Indonesian and have been living in Indonesia. This time, they headed to Australia and had a road trip there. JJ owned his own car in Australia and decided to drive it on their road trip day. But due to JJ's negligence, the car they are riding had a collision with a big old tree. It caused Jojo to hurt severely. The choice of law. There are two options, including Indonesia, based on the Lex Domicili and Lex Patriae, and Australia, based on the Lex Loci Damni, where the collisions happened. Primary links are factors and circumstances that shows we are dealing with international civil law events, or factors and circumstances that indicate that a relationship or event is an international private law event. So we use the Indonesia's law to resolve this case. Because I said this is a private international law case, certainly we cannot miss out the foreign element. It is very clear that the foreign element in this case are where the collision happened, which is in Australia. So the last case is a hypothetical case talking about an Korean citizens get married with an Indonesian girl and stay in Indonesia for good. While visiting Korea for business trip, he fell for another woman and has an illegitimate child there. One day, the man died in a car accident. Then his legitimate son and his illegitimate daughter fighting over his asset in Indonesia. The husband is from South Korea, married a woman from Indonesia. They held the wedding in Indonesia and stayed in Indonesia for good. The couple then gave birth to a boy in Indonesia. The husband often visits South Korea for business purposes, but as time goes by, he then fell for another woman in South Korea. The third party is the South Korea citizens. The husband eventually cheated behind his wife's back and had a daughter with the third party in the South Korea. Time passes and the husband became a very successful businessman and has a lot of assets and properties in Indonesia. One day, he is found dead in a car accident. This caused his wealth to fall into his children's hands. The one and only legitimate son is surely the successor of his late father's wealth, but upon hearing the news, the illegitimate daughter from South Korea also fight for a part of her shares. For this case, there are more characters involved and more link points compared to the other cases. Which law should we use to resolve the case? Let's take a look at the linking points. The choice of law are Indonesia, based on parties' nationality and domicile based on where the official wedding is being held, or lex loci celebrationis, based on where the accident occurred, lex loci damni, and based on where the property were, lex loci actus. South Korea, based on the parties' nationality and domicile, and based on where the unlawful act occurred, or lex loci delicti commissi. Based on the linking point, we can determine that the law and the right forum for the case is Indonesia. Moreover, the locations of property and assets is also in Indonesia. As well as the other cases, in this case there is also a foreign element in the form of citizenships of the parties involved. The parties were the husband himself, the third party, and their daughter who is from South Korea. So before I end this video presentations, I want to give a little conclusions about the material of private international law. Private international law is a law that is administered between private citizens of different countries. One of the most important things in private international law is the link point. Link point are the factors and circumstances that show that we are dealing with events of international private law, or the factors and circumstances that show a relationship or event is an international private law event. After the link point, next is the choice of law or the proper law for the case. Choice of law is a procedural set of rules used to select which jurisdiction's law apply in a lawsuit. Last but not least, foreign element. One sure thing that I've been mentioning since the beginning of this video. It is the most important element to decide if this is a private international law case. A dispute can be classified as an international private law dispute if there is a foreign element, where the dispute may not be fully or not from Indonesia. The problem does not occur in Indonesia, the interference of other countries other than Indonesia in a dispute. The end of the video. Thank you for watching these video presentations.